Hello, this the video is to cover tax law changes as it relates to IRAs. In this first slide, the comment is that contributions to your IRA at one time it was you couldn't make them after you turned 70 and a half. That has now changed so that regardless of your age, you can continue to make contributions to a traditional IRA and receive a tax deduction for it. In addition, the Roth IRAs, um, you're able to make those contributions. The total of Roth IRAs plus traditional IRAs contributions cannot be larger than $6,000, or if you're over 50, it could be $7,000. That's essentially what this particular slide talks about. In the next slide, um, it says that um, the distribution can be made. You can withdraw up to $5,000 for the birth or adoption of a child without incurring the 10% penalty. So that would be another exception um, that would be added to the Form 5329. In the third slide here, um, this talks about that required minimum, the distribution um, is no longer required. So if you took out an RMD, you could return that into your plan if it was made by August 31, 2020. You would normally have 60 days to roll over the distribution. That apparently has not changed. So under the new rules for RMDs, if you were born before July 1, 1949, which meant that by December 2019 you've reached age 70 and a half, you would still be required to make that distribution. However, if you were born after June 30th of 1949, now you have you can wait until your 72nd birthday in order to take money, to be required to make a minimum of the distribution. Another new rule has to do with RMDs for designated beneficiaries. This, however, this will not include surviving the spouse, some disabled individual, chronically ill individual, some minor child, or an individual not more than 10 years younger than the account owner. What this provision talks about is that all distributions has to be made by the end of the 10th year after the death of the IRA owner. So presumably if a beneficiary would be someone other than, say, your surviving spouse, um, or a minor child, um, it would not, you would be uh, able to continue it for as long as possible. But I would assume I could see a situation where the beneficiary, if it was an adult child, they would have 10 years to liquidate that IRA. Okay, this slide here is not new, but it just reminds you for you can make a minimum of the distribution if it's going to a qualified charity. So if the client was 70 and a half and over, they can make a direct QCD to a qualified organization, a church, a nonprofit. Um, the maximum that can be contributed is $100,000, but this amount would count towards the RMD. Typically, the way it happens is that the owner of the IRA would advise the administrator of the IRA of their desire to make that contribution to a charitable organization. There were some new provisions for the QCD, and the next couple slides talks about it and it gives examples. For purpose of this presentation, I won't go through it, but the slides would be made available if you choose to dive into it to get a better explanation. From a VITA standpoint, we rarely see any qualified charitable distribution. It may happen, I've seen it happen maybe once or twice a year, and that's pretty much it. So these slides are the examples. As a result of COVID, there are some new provisions where an individual can withdraw the funds from an IRA or retirement plan without penalty. The individual would have to have been diagnosed with COVID, or has a dependent or the spouse diagnosed with COVID, or experience adverse financial consequences as a result of quarantine, unable to work, etc. So pretty much, if this would pretty much apply that if you needed to pull some money out, the penalty would not apply. Now, this slide talks about the fact that they can withdraw up to $100,000 and not be subject to the 10% penalty. However, it would still have to be includable in income. So the choices are that you could either include all of the distribution in income into the 1 year in 2020, or if you choose to spread it out over 3 years. The purpose of spreading this out, of course, would be to keep you in a lower tax bracket and not have to pay the large amount of tax if it were to put you into a higher tax bracket. So what would happen is that you would complete Form 8915E that would alert the service of the distribution and the amount that you're going to include in your income for the first year and then spread out over the next 2. There are some in the event that you don't use up all the money that you withdrew, you can also pay it back. So you can return it to your IRA so that you would not be taxed on it. So again, this is in scope. The 8915E would cover that. But what this does is it allows you some flexibility that if you don't use up all the money that you pulled out, then you can pay it back as long as you notify the service. So the next few slides talks about some examples of how this would occur. Here they received the $30,000 distribution, so they could either put it all in income in 2020 or spread it out $10,000 each for 2020, 21, and 22. And this an illustration of the forms And from a taxpayer standpoint, I'm not sure how that is going to be handled, but it's something they're working on. Another example is that they took out $45,000 and they returned it. They, in this case, the clients did not need it. How much would the distribution would be includable in the taxpayer's 2020 taxable income? Obviously, the answer would be zero because they recontributed at the time within um, within the due date of the return. And how will it be reflected? It would be reflected on the 8915E. So I think as a practical matter, if someone pulled the funds out, and if the reason for it had to do was to have funds available because of a loss of jobs due to COVID, um, that's the exception that you'll see on the 5329. And again, a few more examples. Um, in this slide here, the background is that in prior years, uh, some non-tuition, some fellowship payments, and your stipends received by grad and postdoctoral students were not treated as compensation for IRA contribution purposes, so it could not be used as the basis for making IRA contributions. Well, under the Secure Act, the new rules remove that obstacle by permitting taxable non-tuition fellowship and stipend payments to be treated as compensation for IRA contributions purposes. This change will enable those students to begin savings for retirement without delay. So, um, one example might be a situation where perhaps because of COVID, um, students that were in the health area may have graduated sooner. They were receiving non-tuition the fellowship payments. They could use those monies towards an IRA contribution if they so desired. Um, so I guess the theory's there as far as how much of it we will see. It's not likely unless our clients' some base would be college, some doctoral candidates, um, um, and whether or not we would see them at our sites, it's probably not likely. The difficulty of care payments, the healthcare workers are treated as earned income for IRA contribution purposes, and it's applicable to tax years after 12/31/2015. Again, whether um, we would see this particular situation, again, probably not likely. So that concludes the slide presentation as far as IRAs are concerned. Thank you very much.